I want to thank Lauren and Ariel for joining us again this year. Make the Road New Jersey, every year we ask them to come and give a immigration update. Sometimes there's good news, sometimes there's bad news, usually there's mixed news. So I'm always looking forward to hear what they have to say about what's going on. And the idea here is that for many of us, the adults that we're working with, either they or their family are directly impacted by changes in immigration law and immigration policy. And so it behooves us as people who want to support them to understand what's going on with immigration. And in addition, that what's going on with immigration can turn around and be part of the curriculum in your classrooms, right? So that's what I do with my own students, to talk about what changes are and what changes that they would like to advocate for. So knowing what's going on is really important. At the end of the session, as in every other session, I will drop the link in for those of you that need the professional development certificate. I'll get the PowerPoint and share that after the conference is over, and I'm recording this, so we'll have the archived version on our YouTube channel as well. So then without any further ado, I'm going to turn things over to Ariel and Lauren, and thanks for joining us again.
Wonderful. Thanks so much. Lauren, do you want to introduce yourself first, then I'll go?
Yes, I couldn't get off mute. Thank you. Thank you so much, Eric, for having us here. We're always so grateful to come and meet all of the wonderful educators. We deeply, deeply admire what you all do. I'm Lauren Herman. I am the legal director at Make the Road New Jersey.
Thank you. No, thank you so much for having us. My name is Ariel Gould, and I am the supervising immigration attorney at Make the Road New Jersey. We're super excited to be here. We have tried to summarize what we think some of the most recent immigration updates or over the past year or things that have built on updates that we've given recently are. We cannot cover everything in the time that we have, so this is kind of what we've cherry picked, but hopefully it at least gives a broad overview of kind of what's happening in a way that's helpful to you all.
And it's so funny. I feel like when we started preparing, I was like, oh, there's nothing new. Nothing has changed. And then we started putting it all together. And I was like, oh my God, we're going to have to talk really fast for the hour. So apologies in advance. We're going to try to get through as much as we can.
Yes. Yes. And that said, we both do speak really, really quickly. So if we're speaking too quickly because we're trying to get through it, please someone send a message, raise your hand, speak, and we will try to slow down.
Everybody here's from the Northeast. We can hang.
Amazing. I am not from the Northeast, but I'm from California, and we also speak quickly, so it should work out. So anyways, thank you so much for having us. As we said, so we're from Make the Road New Jersey. Make the Road New Jersey is a community-based nonprofit here in New Jersey, part of the broader Make the Road states with New Jersey, New York, Connecticut, Pennsylvania, and Arizona. And our model is trying to work to support immigrant and working class communities to achieve dignity and respect through community organizing, high quality legal services, support services, policy innovation, and transformative education. And what that looks like, if Lauren wants to take it over.
Yeah, so this is just a list of some of our services. We have legal and health services. In the legal department, we have attorneys working on immigration, housing and employment law, health services. We've been helping folks enroll in Cover All Kids, which hopefully a lot of you know about, but was the expansion to health care for all children in New Jersey, regardless of immigration status. We also do vaccine outreach and education. We have a bunch of adult ed, including ESOL. We help people prepare for the driver's written test. We have citizenship classes. So if any of your students are currently interested in applying for citizenship, please send them our way. We would love to have them join our classes. We can also help with their applications. We have a leadership school for our members who want to develop additional skills. They learn things like how to facilitate a meeting, how to do outreach, how to talk to the press. We have a student success center where we have a peer-to-peer model where young people help other young people understand and apply for college and financial aid. And we have our community organizing committees that meet weekly, do know your rights trainings, talk about the issues that are affecting them, and work on campaigns to improve their lives.
So just a few of the campaigns that we've worked on and like to claim as victories that we've had some sort of hand in, a $5 minimum wage, including teen workers, occupational licenses for all independent of immigration status, protections against wage theft, universal representation for detainees in immigration proceedings, access to state financial aid for students, a student success center that Lauren was talking about, where we have the assistance with the applications and the planning, the financial aid, driver's license for all independent of immigration status, tax. We work, as we said, as a membership-based organization. So our directions, our campaigns, the policies that we're advocating for are coming directly from what we're hearing from our members and from our community about what they need and what's most important to them. And I think probably the newest member of this list that we have here is the Temp Workers Bill of Rights, which was a really exciting development, I think, in the past year or so, which is just protections and a huge number of kind of employment protections for people that are working for temp agencies who used to fall outside of a lot of the different legal standards or legal protections or legal rights that other employees had.
Okay, so we're going to dive into the updates. The first thing we're going to talk about are the new T visa regulations, which USCIS finally put out. And these have been in the works for many, many years. Advocates have been waiting for these. Does anybody know what a T visa is? You can raise your hands. You could put it in the chat. Eric, it sounds like you know.
Right, either way, so people can either, right, for participation, people can either raise their hand or unmute or put it in the chat.
Oh, could you share what that is?
A T visa. So we have one person who says no, they don't know.
Looks like no one's rushing.
Anyone else?
their hands
Awesome.
up.
Nobody's rushing. Okay, so a T visa is temporary. That's a good guess. So a T visa is a form of immigration relief for survivors of trafficking, exactly, human trafficking victims, right? So it's available for someone who has been the victim of a severe form of human trafficking, which is just the legal definition. It includes both sex trafficking and labor trafficking. I think the most important thing to note is that many people have misunderstandings about what trafficking actually is. And I think a lot of it is the media's fault, right? You imagine a blonde white lady locked in a basement with her arms handcuffed to a chair or something like that, right? And often that is not the trafficking we see, right? It's somebody who is a nanny who's being forced to work for the family. It's somebody who's in landscaping, who's in a restaurant. There are many, many different ways and many different industries that we see a lot of trafficking. And so it's important to first and foremost debunk that myth. So somebody can apply for this visa if they are a victim of trafficking and they have cooperated with law enforcement for the trafficking. It's important the trafficking has to have happened in the US. So, all right, we now know what a T visa is. It's also one thing that's important to know is it can become a pathway to a green card. So even though the T visa itself is temporary, it's available for 4 years. At the end of those 4 years, the person can then apply to get their green card. So the regulations that just came out this past year help to guide how USCIS makes decisions about these types of applications. And so there have been a lot of questions or things that we maybe thought were their practice, and they've clarified some of them, including one very helpful development, which is a new bona fide determination process. So previously, once you applied for the T visa, there was nothing for you. There was no protection, no work authorization until the application was approved. Now, beginning this August, there's this bona fide determination process where you can get some sort of protection and work authorization while the application is pending. So that's really, really helpful. Additionally, the regulations provided some definitions for terms that were previously a little bit vague. So what is involuntary servitude? What counts as serious harm? What counts for law enforcement involvement, as well as reasonable requests for assistance, right? So in order to be eligible, somebody can't refuse reasonable requests for assistance, but that doesn't mean that the case has to be completely prosecuted and the trafficker is put away in jail for 10 years. And often that's not what happens. And the last thing that these regulations do is they specify one of the requirements for the T visa is that you have to show you would face extreme hardship if you were returned to your country of origin. And so this explains that you can show extreme hardship to other family members. So for example, a child, but you have to loop it back to yourself to say, you know, my child would suffer severe hardship if I was deported, and that would cause hardship for me, right? So you have to make sure that it goes back to the original applicant. But basically, this is a really helpful guidance, and the bona fide determination process is huge and really helpful for folks. These are taking about 1 to 2 years to adjudicate right now. So, you know, getting someone's status during that time is great. Sorry, Ariel, go ahead.
No, that's awesome. And the one thing I would want to add for the T, I don't know how many people have heard of like a U visa, which is the U visa for victims of certain crimes, and there's like a 20-year wait list. It's like a very, very, very long wait list for U visa for U visa applicants. T visas, I think, has historically been an application process that has not as many people have been aware of, not as many people have been able to screen for. And so there is, as far as I'm aware, still not a backlog, and tends to be the processing times are whatever the government takes to decide it. That said, the other benefit of this bona fide determination, which is really exciting, is there are annual limits on how many T visas can be issued per year. So if you get to the point, which we hope that we get to, which is that everyone who really should qualify for T visa is able to find the legal systems to apply for it, this provides something intermediate for them if they get in a situation where they also have a backlog or a wait list before the visa can be issued. Okay, so the other is we also updates to TPS in the past year. I will slow down, thank you. Does anyone know what TPS, has anyone heard of TPS or know what TPS is?
Yes.
Okay, does anyone want to give a try for what, like, to explain what it is?
Temporary protective status.
Mm-hmm. Exactly. So TPS is temporary protected status, and what it is a temporary status for people from certain designated countries. Those countries are designated by the US government for specific reasons related to unsafe conditions, natural disaster or war. I think the most kind of clear examples are ones that I've heard of the most outside of the immigration services community really is if you look at Afghanistan and Ukraine as countries that have recent designations relating to what's happening at the national level for them. But there are a lot more countries besides Afghanistan and Ukraine that also have it. Yes, and Haiti as well. And we'll get into Haiti in just a second. Haiti and Venezuela. So basic requirements for TPS, it is temporary. In order for it to extend beyond a given period, the government has to extend the designation of that country. So what it becomes is a series of designations over time, and it's not a permanent status, but it is a temporary status. It gives protection against deportation. It gives the right to apply for a work permit. And it also, as opposed to some other temporary statuses, gives the right to apply for travel abroad. So someone with TPS can't just leave the US and come back, but they can apply to the US government for the right to travel abroad and return. It's something called advanced parole. So the other requirement is that there is, as I said, it's based on a timely designation. So there's usually a requirement in terms of when you have to have been in the US and residing in the US to be able to apply. And you need to keep up the registrations with the TPS. So certain countries have really recent designations, Haiti, Afghanistan, Ukraine. Some countries, El Salvador has had a designation since like 2001. And so someone who's coming in now can't apply for TPS, but someone that has had TPS from El Salvador since 2001 can continue to renew as long as that's extended by the government. So these are the countries that are currently designated for TPS. We're going to talk about a couple in particular because they're the ones that we've kind of seen most recently, at least in our communities. Afghanistan, Ukraine, also Venezuela, El Salvador, and Nicaragua. So over the past year and change, the Biden administration has redesignated or extended designations or designated certain countries. One in particular, El Salvador, as I said, this has been going on since 2021. They currently have TPS still. It was extended in June 2023. and it continues until March 9th, 2025. The really important thing that I want you all to know when we're talking about this, if you have people that you think might qualify or that have it already, is there are re-registration periods. These re-registration periods have historically been relatively short. I mean, not days short, but definitely months short. And under recent announcements, they've actually extended redesignation periods or the re-registration periods, apologies, for several countries until the end of the TPS designation. So even if someone hasn't applied to re-register now, if they're still within that re-registration period that we have outlined here, they can and they should, if they're still eligible. So just talking about some of the countries, so we have El Salvador, announced the extension in June 2023. It's extended through March 9th, 2025. And the re-registration period is July 12th, 2023 until March 9th, 2025. The other thing that's really important to note and kind of these changes in the announcement is you have this like EAD is an employment authorization document. It's a work permit auto extended. That means that someone that had this work permit that would have previously expired with the last TPS period, it has an auto extension through this period, regardless of whether or not they've currently applied to re-register. If they apply to re-register, then there's a second auto extension that applies to a lot of different work permits under a lot of different categories, which is 540 days to provide the government the time to adjudicate that application, right? So the auto extension is important, just to note that it also doesn't tend to run to the end of the re-registration period. So like El Salvador, the auto extension is only through June 30th, even though the TPS designation and the re-registration period runs through March 2025.
And I would just add, these dates are incredibly confusing. Like, don't ask us why they did that they didn't have the auto extension go to the end of the period. It makes no sense. And it's confusing for us. It's confusing for clients, for students, but it's also confusing for employers, right? So often if someone has an auto extended EAD, it means that they are work authorized, like they can keep working lawfully, but employers are very, very confused by seeing a work permit that has an expiration date that is, that has already passed. So I think it's a good place to really help support students who might be in that situation and help them explain that to their employer. Often we'll recommend that people print out the web page from USCIS, and we at the end we're giving you guys the link. So we recommend that they just print out that page and bring it to the employer and like highlight where it says that it's auto extended. Sometimes employers accept that, sometimes not. Sometimes they have to call us, but they really should accept it because they're not getting mailed a new work permit with the updated dates.
Yeah. Thanks, Lauren. And so in any auto extension with immigration, employment authorization documents, be it TPS, be it the 540-day extension that I mentioned earlier, none of those come with a new work permit. It's all just like, I have this receipt and this printout from the government, and please accept this as proof of work authorization. They will not get a new work permit until the new application is adjudicated. So you'll also note, so El Salvador has one line, right? But Venezuela has two. You have Venezuela 1 and Venezuela 2. And that's because when they did the most recent announcement about Venezuela, they did two things. They extended a previous TPS designation and they issued a redesignation. So now you have two periods. You have people that had TPS already, and that's this extension announced, when it's continued through, when the re-registration period is with the auto extension through March 10th, 2025. But you also have people that had never had TPS previously from Venezuela. Either they did not qualify under the initial announcement because they came too late, or they just forgot to apply or didn't apply or didn't know about it. And there's a new period, and the registration period for that is through April 2nd, 2025. And when I talked earlier about physical presence and continuous residence, those we've noted only for the new designations because there's something to be aware of when someone's thinking, do I qualify or do I not? So under this, someone who came from Venezuela in 2024 does not qualify under either TPS designation. But someone that came on February 10th, 2023 does under the new designation, even if they hadn't previously had DPS or hadn't qualified previously, as long as they meet other requirements regarding convictions, things like that, that they should consult with an attorney about. But just generally, the really key things to note tend to be this continuous residence, physical presence, because that tends to be the clearest screening for them. Ukraine and Afghanistan, which I mentioned earlier, and we'll skip through pretty quickly because I feel like they've been in the news lately, but I've seen, at least for us, we've seen fewer people coming from Ukraine and Afghanistan to search for our help. also have 2 designations, and initially, like a previous designation that has been extended, and a new designation with a new physical presence period that they can still register for. Haiti also has 2. So the thing to note for Haiti is really to keep in mind these different dates. The extension was announced in 2022. It's for both announcements through August 3rd, 2024. The registration period for someone who has not had TPS from Haiti before ends August 3rd, 2024. So you can still currently register, but you have to have been continuously resident or like living in the US since November 6, 2022, and physically present. That's except for like very brief short absences since February 4th, 2023.
Do you
Okay.
know, wait, quick question.
Mhm.
If someone's visa is about to expire, can they apply for it?
My guess would be that someone that's on a current visa came too late. Usually, when someone enters on a visa, they're given an entry of about 6 months, which meant they wouldn't have met these continuous residence physical presence dates.
Thanks.
And then Honduras is also one that's been around for a while, only has 1 extension, and just to note that the EADs are auto-extended till June 30th. So TPS, as we said, is a really strong benefit, and people who can apply for the first time and are eligible to do so, we really strongly recommend that they do, because it gives a work permit, a social security number, protection from deportation. Like, there are a lot of benefits associated with it, but being cognizant of those continuous residence physical presence days, and also they really should consult with an attorney because there are a couple of more complex pieces of analysis to do. The other thing that I do want to note, and because you may get questions about this, is because it does depend on the government continuing these designations. TPS does not provide a route to a green card, does not provide a route to permanent status. So if the government chooses not to continue designating the countries or extending the designations, then someone will no longer qualify for TPS if their country is no longer designated.
And I would just add to that like historically up until the Trump administration, TPS designations generally were extended, which is why some of them you'll see, like the Honduras designation goes back to 1999. So, you know, it wasn't until very recently that there was more of a threat that they may not be continued. Okay, so now we're going to talk a
Lauren, can I
little
say-
bit.
I had one
Yeah.
quick thing. So yesterday we had a session on advocacy goals for us as an organization. And one of the things that we talked about was, in addition to advocating for additional money for adult education itself, there were other campaigns that we should be a part of that impact our students' lives, right? And it seems like TPS issues would be certainly in keeping with that, to make sure that you know, it's extended and that people get the coverage that they need.
Totally. And there's currently a lot of talk about creating a new designation for TPS for Ecuador. You may have heard some of your students talking about this. It does not yet exist. If you hear of notarios or bad lawyers who are charging people a lot of money to get on the wait list for Ecuador TPS, like, it does not exist. And I say that because we've seen that in the past when there's like a lot of chatter about a potential new benefit. You get the like vulture type notarios who are going to tell people like, oh, come to me, give me $1,000 and you'll be the first on the list when it comes out. So yeah, it doesn't exist yet, but hopefully it will. And that's definitely a place where advocacy is really helpful. Okay, so I'm going to talk now about SIDGE and the SIDGE backlog. Again, is anyone familiar with SIDGE?
No.
It's an acronym, no.
Yeah, cue crickets chirping, I think. So
All right. So SIDGE stands for Special Immigrant Juvenile Status. It's a form of immigration relief for a young person who is under 21, who is unmarried, and who has suffered either abandonment, abuse, neglect, or a similar basis, something similar to one of those things, by one or both of their parents. So it's a form of relief that we see a lot for a lot of the young people that we work with, and your students may have kids who are going to be eligible for SIDGE. The super important thing is the minute they turn 21, they are no longer eligible. So it's a type of relief that it's really, really important to screen early, and I would even say screen often, right? Because family situations change, and if they are abandoned or abused by a parent, they could be eligible. The process is a two-step process, and it actually starts in a family court. So in order to apply for immigration, they need to have an order from the family court that says they meet these requirements. Typically in New Jersey, we do that through a custody process, but it doesn't have to be a custody process. It can also happen in the juvenile delinquency docket. It can happen in the abuse and neglect docket. It can happen through the parents' divorce. If the parents are getting divorced, they can ask to include this as part of that process. And then, once they have that family court order, the kids can apply to immigration.
Sorry, and just to add the 21 age, this is also, we'll get into a second. You saw it in the title, SIDGE backlog. The 21 age is very important because that is the cutoff for the first step with immigration. So when you get through family court, you do the initial filing with immigration. As long as that is received before the child turns 21, even though they're 20 years old and 364 days, they still qualify. It doesn't matter if they turn 21 after. But if that application is received on their 21st birthday by immigration, they no longer qualify. So the key there is at the time of the first filing with immigration, are you under 21?
Thanks, Ariel. And actually, I realized we didn't put an additional update here, but we'll add that at the end. Okay, so the major thing, there's two major things actually that have changed in SIDGE. So the first is the SIDGE gives you special immigrant juvenile status, right? And that like the bona fide determination is sort of a temporary status, but you can then apply for a green card. The tricky part is you can only apply for a green card once your priority date, which is the date that you submit the application, is current. And the SIDGE applications are lumped in with other types of employment visas, and there is currently a backlog for those applications. Previously, the backlog only applied to young people who are from countries that had a lot of applicants. So, there was a long backlog from Mexico, from Honduras, from El Salvador. In 2023, they changed the way they think about the backlog, and now all of the countries, like children from any country, are subject to the same wait list, the same backlog. So you'll see on this next slide, this is what the visa bulletin looks like, and we're going to give you a link to where you can find the visa bulletin if you have families where a young person has special immigrant juvenile status and they're waiting to be able to apply. This is what it looks like. This is how you apply. You have to go to the final action dates. There's two charts. One is for filing dates. One is final action. You have to use the final action. And it's the fourth category. And then you can see it's all the same. So currently it's November 1st, 2020. So what that means is that if somebody submitted their it's the Form I-360 to USCIS to immigration before November 1st, 2020, they are now eligible to apply for their green card, which is great. So it's backlogged about 4 years. This visa bulletin changes every month. So, young people who are waiting on this really should be checking every month to see whether they're going to be eligible to apply. The other major change in SIDGE, and I can't remember if it was this year or previously, but so because that 21st birthday is such a hardline deadline, people, including us, have done all sorts of crazy things to get those applications to the office before that deadline passes. And so if there is a snowstorm or a FedEx delay or something like that, previously it would mean that kid was not eligible anymore. If you didn't get the family court order until a couple days before their birthday, and for a reason even out of their control, it wasn't delivered before their birthday, they would not be eligible. They would lose this option. And so there was a lot of advocacy and a couple lawsuits saying that this is incredibly unfair. And so USCIS created a process whereby if you are within a couple weeks of the child's 21st birthday, you can request an in-person appointment at the local USCIS office to bring the application in person and get it filed. So previously, all of them were getting sent to Chicago, where there's a lot of weather-related delays in mail. And so now, if there is a young person that's coming up on their deadline, there are additional options so that they can get it filed in time and hopefully not miss that deadline.
Yeah, and we wanted to like highlight this because this is something we see, and when we're talking to even like our adult clients, we get a lot of questions about like their children and what can their children do. And this is a really, really common relief option for children in particular. I mean, obviously until 21, but it's a very common relief option. And also because we see a lot of questions, because this process lasts so long, we have 23, 24, 25-year-olds coming up to us and saying, but my friend is also from Ecuador and theirs went through really quickly, and why can I not do mine, and why is it still waiting, and all of these questions about it. And there's, because it's this huge change from years and years and years of practice that happened last year about the way that it's calculated and the fact that every country now has a wait list, there's still a lot of misinformation, a lot of disinformation, and we do not infrequently see the result being that someone goes to a notario and the notario says, no, you should have been able to do this already, charges them however much money for something they really couldn't do yet because they just tell them, oh no, you can file it now. So wanting to make sure that everybody's aware. Two things I want to add really quickly, just because it sounds like this is kind of a new thing to be cognizant of for a lot of us in the room, is that there was a change as well in 2021. Previously, anyone who was backlogged, that was it. There was like nothing for you while this was pending, while you're waiting to apply for your green card. In 2021, they created a process for deferred action. So now when that initial petition with immigration is filed and adjudicated, if you're backlogged, which at this point is everybody, they will review it for deferred action. Deferred action is a protection from deportation, and it comes with a right to work permit. That deferred action lasts for 4 years. Because it was only created in 2021, we do not know what happens or how. Hopefully something we'll find out next year. But it is something to know because it does give a right to a work permit and protection against deportation for kids that are waiting in that backlog, or young adults that are waiting in that backlog. The other thing, two other things to note, sorry, really quickly. One is that there was a change in rules as well, and I cannot remember the year, but it was in the past like 2 or 3 years, which is that it previously had to be that the child could not be married throughout the entirety of the process. So they could not get married until they had their green card in hand. The rule has since changed that they cannot get married until the first petition with immigration is approved. So while they're in that 5-year wait for their green card, as long as that first petition was approved, they can get married. We generally still recommend people hold off because it's new and you never know if policy is going to go backwards, but in theory, they should be fine and safe to get married at that point. The other thing to note for the parents is that a child that gets a green card through SIDGE can never petition for their parents, neither parent. Sorry, that's not recent developments, but
Yeah.
things to be aware of when you're thinking about it.
So that seems to me like another avenue for collaborative agency, right? The fact advocacy, that the fact that neither parent, if you're the parent that took the child out of the difficult situation, you're being punished for what the partner did. Certainly, I would hope that there's people that are working on that as an issue, and that's something that we could support them with.
Yeah, I think definitely are, and against the backlog as well.
Yeah, so there's a coalition of folks, the SIDGE Backlog Coalition, it's called, that's working to try to get these petitions taken out of this random fourth employment-based preference category, which would mean that they could just apply for their green cards at the same time that they apply for SIDGE, and they don't have to wait in this backlog. So there's a lot of movement to push in that direction. I don't know, Ariel, if you have. I actually haven't heard that much about people pushing to try to change the rule about parents never being able to benefit. I think the reason it's in there is because SIDGE used to be only available to kids who were eligible for foster care. So by definition had been abused, abandoned, neglected by both of their parents. And they changed it to allow for single parent SIDGE, which was great and opened up the possibility for many, many more young people. And I think they never updated the rest of the law that says the parents can never benefit. So yeah, it certainly would be a huge and important change.
Yeah, I've seen there was when they had proposed rules out, because there were new rules, new regulations for SIDS that came out a few years ago, there were a lot of comments made about making it not be both parents that were disqualified. But the main, I think, advocacy going on right now is a SIDS backlog. And Lauren, I think there was one question that came directly from me on SIDS, if you want to answer it, which is like, could filing this application trigger a DCF investigation?
That's a good question. So I would say filing the application with immigration probably won't. At that point, you already have the order from the family court judge, and just filing it with immigration. Like, we get a lot of parents who are worried about that. We have a lot of parents who maybe abandon their kids, they're not in good contact. And then when they hear that we want to file this for their kid, they'll like put up a big fight because they think they're going to get in trouble. I would never promise someone that it couldn't affect them because we truly don't know. But I can say that in the past 10 years, I've never heard of someone that had a negative impact because their child applied for SIDS. And I think it's pretty unlikely that immigration is going to like connect all of those dots and take an application that a child submits about SIDS and then connect it to their parent in a completely different matter. For DCF, I think depending on the situation, when they file with the family court, if the family court is very concerned, they could start an investigation. And, I think that would mostly be likely if the child was still in the household. Most of the cases that we see, the child is already safe, right? They're no longer living with the parent that was abusive or neglectful. And so, I don't think that the family court is likely to call DCPMP at that point if they think that the child is no longer in danger. But I do think that that's a potential risk if the child is still in a dangerous situation. And just, to cover all of our butts, there is a requirement in New Jersey. Everybody is a mandated reporter, right? There is no, it's not just certain professions that are mandated reporters. Anybody who knows that a child might be in danger is obligated to report. So I think like under that standard, if the family court believes that a child was in danger, they might do that. That said, we know that sometimes DCPMP is very helpful and protects children, and sometimes they can cause more problems. And I think, we care very much about making sure that young people are safe and are not in harm's way. But, want to really take the lead from their families to work to make sure that that happens in the best and most peaceful way possible.
And also to add, just as an added level of protection, particularly to the individual that is petitioning for custody of the child. In New Jersey, the way the law is currently written, and I'm going to speak specifically to custody proceedings because that is generally the way that SIDS is done in New Jersey, or the most common way at least. The person that has to file that petition is the potential custodian. The child is not filing it, which means that any attorney that is assisting with them is technically the attorney of the petition person filing that petition, and as such should be giving them a really candid analysis of what's going on, of any possible prejudice to the proposed custodian, so that they are able to make an informed decision about whether or not they want to go forward.
Any other questions on that? I know that's a tricky and important one before we go forward.
I don't see any in the chat, so you can go forward.
Awesome, thanks. So on to new and fun news, and this one really is a mixed bag, which is new fees, which is that as of April 1st, there is in effect a completely new fee schedule, and fee schedule is what the government calls the list of fees for all of the different applications. As I think all of us are aware, the vast majority of immigration applications have not historically been free. So they went through and reanalyzed their fees for pretty much all of them. So for most applications, what this meant is that there was often a not insignificant increase in the fees. How significant or not, depending on the form version, we can't go through all of them. It's pages and pages long, but we have a link for it at the end. Some important things to note, though, is previously people who were applying for a green card, if you paid that fee for the green card, which anyone going through a family member, for example, had to do, then a travel permit to travel outside the US, a work permit, all of that was included in the green card filing fee. You just paid one fee and you were done. Under the new, and anytime you had to renew, that was it. Under the new filing fees, they have uncoupled all of those fees. So now someone who's applying for a green card has to pay separately for a travel authorization, has to pay separately for a work permit, and it is significantly more expensive. They are trying to funnel applications through an electronic filing system they have. This is only for applications where there is no fee waiver or reduced fee waiver. Those cannot be filed electronically. But for the most part, there's about a $50 difference between those filing on paper and those filing electronically. I won't say that that's every single fee, but the ones that I've seen, there's about a $50 difference pretty much
Which one's
consistently.
cheaper? Which one's cheaper?
Filing online is cheaper. So they are trying to funnel people into filing online. Which is a mixed bag, right? On the one hand, when you file online, you get a receipt notice almost immediately. You have, in theory, your notice is uploaded online. It's easier to track, but you also need to be tech savvy to do it. And at least for us, for a lot of the people that we work with, that is a difficult ask. And it actually takes a fair amount of work to try to figure out how to log into the account, how to create the account, how to file it. So some people are still, for us at least, opting to pay the $50 extra and just file on paper. The other big change, specifically in the context of naturalization or citizenship, is it used to be that, so for citizenship only, there is a fee waiver, which is like there's no fee at all because you're under 150% of the federal poverty level or qualify under like one or two other exceptions, or a reduced fee, which is you pay about like half the fee. So that used to be that for the reduced fee that you were under 200% for your family size for the federal poverty level. That has been extended to 400%. So there are now a lot more people that qualify for a reduced fee for the citizenship application than previously did, which is good news. The other happy news that came under this fee change is that people that have certain humanitarian applications, these are the U visas we talked about for victims of crimes, the T visas we just talked about, VAWA, which is the Violence Against Women Act. So you are the spouse, minor child, or in certain cases, parent of an LPR or US citizen, depending on the category you're applying under, who was abusive, and you are applying under that basis. And SIDGE, which we also just talked about, for them, every application associated with that underlying humanitarian petition, including waivers for inadmissibility, which are necessary for U's and T's and sometimes for VAWA and SIDGE, work permits, green card applications, none of those have any fees up through the green card process, and there's no need to prove that they can't pay. So previously you could apply for a fee waiver for those. SIDGE for a long time has been that if you showed them their instructions in the correct way, they wouldn't charge you for it. But U's, T's, and VAWAs no, that you'd have to show that you had a public benefit, your income was under 150% of the poverty level, or that you had other financial hardship, which is really difficult. It's very inconsistent how they apply that standard in order to get them not to charge you or to waive that fee for you. Now it's waived automatically without the need to show financial need. Oh, the flip side to this, and it's not on here, but also going through and being like all these updates, just for anyone who to be aware, and I don't know how relevant it will be for you all, but they also, when they did this fee schedule on April 1st, republished many of the immigration forms. So anyone that had been working on an application on one of those old form versions, that they have to file it before June 3rd. If they don't, they can still apply, but they need to move to the new form versions or their applications are going to be rejected. So if you have someone that's been working on citizenship for 3 months, they really need to check their form version or they need to apply before June 3rd.
Okay. DALE, or Deferred Action for Labor Enforcement. So I think we talked about this last year. It was a new change that came out last year. Our update for you today is a positive one, which is that we've finally seen some of these cases getting adjudicated, and for the most part, it's been great. So, right, this is a new streamlined process for workers who have experienced labor rights violations. Like some of the other temporary statuses we talked about before, they can request deferred action and work authorization for a 2-year period. Another piece of this that is actually very exciting and I think underutilized is that they can request parole in place, which previously existed for military family members, but basically they can ask for like a lawful entry. And so if they may be eligible to have a child petition for them, but they entered over the border and so they're not eligible to get their green card here in the US, if they're able to apply for DALE and apply for this parole in place, it could cure that entry and allow them a pathway to a green card. So even though the DALE itself does not provide a pathway to a green card, it could open up a pathway to a green card, which is very exciting. In order to apply, the worker has to have a letter of support from an investigative agency. Again, one thing that's really special, I would say, about the DALE applications as opposed to like a U visa or a T visa is that that letter of support applies to all of the workers in that workplace under investigation. So whereas a U visa, every single applicant has to request that the police issue them a certification, here you could get the statement of interest from the labor agency that covers many workers, and we've seen the labor agencies have been really supportive of this change and are issuing statements of interest that are very broad. So for example, we have one right now that covers all of the workers in 3 of the major temp agencies since 2017. So like that's huge and could open up possibilities for a lot of people to apply for this relief. We've seen pretty quick turnaround. They're usually approved in about 6 to 8 weeks, which for immigration is like lightning speed. The one downside is that we don't know what's going to happen at the end of that 2 years, right? It's a 2-year period. There are folks who are advocating for working on pushing around renewals, but I think there's a lot of fear that, you now just handed over all of your information to immigration, and at the end of 2 years, that's going to be it. And you're stuck with nothing. But I think, we've seen an uptick in applications. It was very slow at first. There weren't that many people applying. And so I'm hopeful that we'll be able to like build a critical mass of people who get this status so that they're then able to keep advocating and fighting for it.
Okay, in our last, we also talked about this last year, and there's not really too much new to talk about, but just because it is kind of a constant topic and a lot of people are impacted by this, just updates on DACA. Is there anyone that doesn't know what DACA is? Should we go over what it is before I go through it?
I think people know. Yeah.
Wonderful. I assumed so.
I don't know.
Okay, so DACA is Deferred Action for Childhood Arrivals. It was an Obama era executive action that created deferred action, which, as we've talked about, is this protection from deportation and a work permit, and in this case also the ability to apply for travel authorization outside the US for like people that had come to the US as children, like before their 16th birthday, and met certain dates about when they came and how long they'd been here. It's been under the Trump administration. They attempted to rescind the DACA program, and there's been litigation ongoing ever since. The current status of DACA is that people that didn't previously qualify because you had to be 16 years old for the most part to apply, for example, or just hadn't applied in the past and could have, they can submit applications, but those applications cannot be adjudicated. They're considered initial applications. The other thing to note, and that's important as in what is an initial application, someone that has had DACA previously, but their DACA has expired for more than a year, if they now try to what you would think is renew because they've had it previously, if it's been over a year before they applied, since the DACA expired, that is also considered an initial application. You can pay for it, it can be receipted. It is not going to be adjudicated until the litigation is decided. But people that have current DACA or have had DACA and it's been expiring for less than a year can continue to renew under the current status of the litigation. And DACA is granted generally for not generally, DACA is granted for 2-year periods. And we're seeing occasionally 2 weeks, but often now about 3 to 4 month adjudication period for DACA applications. So people should try to apply early. DACA, unlike some of the other employment authorization categories that we talked about, does not have an auto extension. So if you apply to renew your DACA and while it is pending, your work permit expires, you do not have work authorization, which is something to keep a note in the timing of the applications. If someone's asking or talking or you hear about it. But anyways, so what's happened is this essentially the litigation is ongoing, has been ongoing for many, many years. In September so when Texas and other states have sued to stop DACA. They've argued that it's illegal and overreached by the executive branch. The Biden administration has attempted to cure what they're citing as defects in the way that DACA was promulgated. They issued new regulations. And in September 2023, a federal judge in Texas declared that the 2022 Biden administration DACA rule was illegal. He said that this new rule did not cure the deficiencies in the previous rule, but he did not enjoin the program. So what he essentially said is, no, this didn't cure it, but he did not extend beyond that. And so we're still in the status quo from before September 2023. I think most of us in the Immigration Legal Services community expect that this litigation is going to be ongoing and is likely to get back to Supreme Court. It has previously gotten there and been dropped back. It's been years and years and years of many different cases from many different states. But we expect it to get back, and full transparency are not overly confident about what the ultimate outcome of that case is going to be. So, and I think with that, sorry, go ahead.
No, I was just going to say, I think that that's, Eric, to your point earlier, that's another important place for advocacy. Like, I will add to what Ariel said, I don't think anyone is super hopeful that the Supreme Court is going to, on their own, come to a good decision about DACA. But I do think that it's interesting to observe that nobody has wanted to be the one that ultimately pulls the plug on DACA, right? I mean, except for President Trump when he did, right? But like, all of the courts have sort of been kicking it around because they know it's an incredibly popular program. They know that there are thousands and thousands of young people who have benefited and families who have benefited. And I think it is really unpopular to be the one to end it. And so I think the more pressure that can be placed on any and all decision makers to both continue the program, but more importantly, to make more permanent pathways for these folks so that they're not dependent on the whims of the court, on the whims of the administration, and on having to apply and pay over $500 every 2 years, the better. So I think that that's it. We did it. We made it to the end. Woohoo, 3 minutes to spare. So here is the list of resources, which just covers all of the programs and the updates that we talked about to give you guys resources to share with all of your students. And we're happy to take any questions you have in the remaining moments.